You've been in an accident and you don't want to get screwed over by the insurance company, then listen up. Today we're tackling a topic that's crucial for anyone who's been involved in an accident. The tactics insurance adjusters use to minimize your claim payout. See, after an accident, you're often vulnerable, dealing with injuries, medical bills, and emotional stress. The last thing you need is to be taken advantage of by an insurance company whose primary goal is to protect its bottom line, not your best interests. Insurance adjusters are highly trained professionals. They know the ins and outs of policies and they're skilled negotiators. While many are ethical, their job is inherently to pay out as little as possible. This isn't a conspiracy, it's just how the business works. But understanding their strategies can empower you. In this video, I'm going to reveal the top 3 tricks insurance adjusters commonly employ to lower your settlement, and more importantly, how you can protect yourself. Stay tuned because this information could save you thousands of dollars and ensure you get the compensation you truly deserve. The first trick is the early lowball settlement offer, often coupled with an attempt to downplay the severity of your injuries. It's a classic move. Shortly after your accident, sometimes even before you're fully assessed your injuries or received a comprehensive medical diagnosis, an adjuster might call with a seemingly generous offer. They'll present it as a quick, hassle-free solution, implying that taking it now will save you time and stress. Why do they do this? Because they know in the immediate aftermath of an accident, you might be desperate for cash to cover initial medical bills or vehicle repairs. They also know that many injuries, especially soft tissue injuries like whiplash or concussions, don't fully manifest for days or even weeks after the incident. By getting you to settle early, they prevent you from discovering the true extent of your damages, both physical and financial. They might say things like, "It sounds like a minor fender bender. Are you really hurt?" Or, "We can offer you X amount right now to close this out. Otherwise, it could take months." This pressure is designed to make you doubt your injuries or fear a lengthy legal battle. They might even suggest that your injuries aren't severe enough to warrant extensive medical treatment, subtly influencing you to minimize your care. So how do you protect yourself? Never accept an early settlement offer without first consulting with an attorney and completing a full medical evaluation. Your health is paramount. Get thoroughly checked by a doctor, follow all medical advice, and keep detailed records. The true cost of your injuries, including future medical needs, lost wages, and pain and suffering, can only be accurately assessed over time. An attorney can help you understand the full value of your claim and advise you against premature settlements. The second trick is to try to get you to give a recorded statement. This is a common request from the at-fault driver's insurance company. They'll frame it as a routine part of the investigation, essential for processing your claim. They might sound friendly, empathetic, and assure you it's just to get your side of the story. But be warned, a recorded statement is rarely for your benefit. The adjuster is looking for inconsistencies, admissions of fault, or details they can later use to devalue or deny your claim. They might ask leading questions, try to get you to speculate about the accident, or encourage you to minimize your injuries. For example, they might ask, "How are you feeling today?" If you respond with a polite, "I'm fine," even if you're in pain, they could later use this to argue that you weren't truly injured. Remember, you are under no legal obligation to provide a recorded statement to the other driver's insurance company. Your own insurance company might require one as part of your policy, but even then, it's wise to consult with an attorney first. Anything you say can and will be used against you. It's a high-stakes game, and without legal guidance, you're playing at a disadvantage. How do you protect yourself? Politely decline to give a recorded statement to the other party's insurance company. Inform them that your attorney will handle all communications. If your own insurance company requires a statement, speak with your lawyer beforehand to understand what information to provide and what to avoid. Your attorney can even be present during the statement to ensure rights are protected and that you don't inadvertently harm your case. The third trick involves shifting blame and potentially misrepresenting California's unique comparative negligence laws. After an accident, the insurance adjuster might try to suggest that you were partially or even entirely at fault for the collision, even if the evidence clearly points otherwise. They might highlight minor actions you took or omissions, attempting to assign a percentage of fault to you. This tactic is particularly insidious because California operates under a system of comparative negligence. What does that mean? It means even if you are found partially at fault for an accident, you can still recover damages. However, your compensation will be reduced by your percentage of fault. For example, if your total damages are $100,000, but the adjuster convinces you or a jury that you were 20% at fault, your payout would be reduced to $80,000. Their goal is to inflate your percentage of fault to reduce their payout. They might also subtly imply that because you were any percentage at fault, you may not be able to recover anything. which is a direct misrepresentation of California law. They know that many people are unaware of the nuances of comparative negligence and will use that lack of knowledge to their advantage. So how do you protect yourself? Do not admit fault at the scene of an accident or to any insurance adjuster. Stick to the facts. If an adjuster tries to assign blame to you or misrepresents your ability to recover damages, it's a clear sign you need legal representation. An experienced personal injury attorney understands California's comparative negligence laws inside and out. They will fight to minimize any attributed fault on your part and ensure that the true negligent party is held accountable, maximizing your rightful compensation. So to recap, the top 3 tricks insurance adjusters use to lower your payout are: 1. The early lowball settlement offer and downplaying injuries. Don't settle before you know the full extent of your damages. 2. Getting you to give a recorded statement. Politely decline and let your attorney handle communications. 3. Shifting blame and misrepresenting California law. Do not admit fault and understand your rights under comparative negligence. Navigating the aftermath of a car accident is challenging enough without having to battle insurance companies alone. Their goal is to save money, and your goal is to recover fully. These two objectives are often at odds. If you've been in an accident in Los Angeles or anywhere in California, don't let insurance adjusters trick you out of the compensation you deserve. The best way to protect your rights and ensure a fair recovery is to have an experienced legal advocate on your side. At Stephen M. Sweat, Personal Injury Lawyers, APC, we understand these tactics and we know how to fight back. We offer a free, no-obligation consultation to discuss your case. Call us today at 310-592-0445 or visit victimslawyer.com. Let us handle the insurance companies while you focus on your recovery. Your future is too important to leave to chance. Thank you for watching.